Herein, she handled matters pertaining to strategic planning, resource planning, monitoring, and providing decision and policy insights. She represented CSIR in various interministerial meetings and forums. Prior to joining CSIR, she was associated with Smart Analyst, a market consulting firm, and a new drug discovery research, Ranbaxy Laboratories. She was instrumental in progressing a drug candidate to phase 2 clinical trials for a chronic obstructive pulmonary disease under the GlaxoSmithKline Ranbaxy collaboration. She holds a PhD from Indian Institute of Science, Bangalore, with specialization in organic chemistry, and has held postdoctoral positions in National Taiwan University, Taipei, and University of Illinois at Urbana-Champaign, USA. Since taking over as a head CSIR TKDL unit, she has been working towards delivering its mandate. TKDL is a tool for defensive protection of Indian traditional knowledge, currently pertaining to the Indian system of medicines like Ayurveda, Unani, Siddha, Yoga, and Soga Trikpa. In addition, she has initiated steps for expanding the scope of TKDL, enlarging information content in its database. In her various teams, she has led interdisciplinary teams comprising members with several disciplines that including masters, PhDs, MBAs, MD, MBBS, and MPharm. To her, she has 30 research publications and has 22 patent applications to her credit. With this introduction, I call upon Dr. Vishwajanani. Doctor, the floor is yours. You can start.
Thank you so much, Dr. Murugan, for the lovely introduction and also giving me an opportunity to speak at the BIIS 10 program. Thank you so much.
Our pleasure.
Yeah. So I understand that today's program will be on intellectual property rights. Yes. So in this context, the traditional knowledge has a very different way of looking at when we are talking of intellectual property rights. And it gives me great pleasure to talk on this subject. Let me share my presentation. Is it visible?
Yes, Doctor, visible.
Is it in slide mode?
Not yet. Yes, now.
All right. Okay. Thank you so much once again. So thanks to Professor Anil Gupta, he keeps giving me this opportunity to talk to everyone in the BIIS program about people's rights. You know, when we are talking of traditional knowledge, it is related to people's rights, and that is what my presentation would all be about. So the title of my talk is the IPR, Patent and Ethical Framework for Exploring People's Knowledge. When you generally talk of the intellectual property rights, very often you forget that there is an ethical framework required. And my talk would all be focused on this particular aspect today. So the outline of my presentation would be general introduction to invention, innovation, and the informal sector. Very briefly, we'll walk through it. Then how is innovation protected, especially from the point of traditional knowledge and grassroots innovation? And what is it that we are talking about when we are mentioning about ethical framework? Why is it that an ethical framework is required when we are talking about grassroots innovation or the traditional knowledge? So this is more to just kind of, warm up slide. Typically, we all understand, I think all the participants are, well versed with science and technology. So just to kind of recap, science is a systematic attempt to understand and interpret what is happening around us. And it therefore requires skills of literacy and numeracy. But when we are talking of, technology, that is not the case at all. We often, it is the systematic study of techniques for making and doing things. So for example, when we are talking of fabrication and artifacts and all that, you don't need literacy and numeracy. It kind of runs through generations by word of mouth or by transmitting the technical skills from one generation to the other. So what is very common in all of this is that you need a creativity of the mind to invent something, and that leads, when it has a commercial aspect to it, it is called the innovation. So when you're talking of invention, it is creating something new that did not exist before. It could be a new solution to existing problem, or it could be improvisation of an existing solution. It is a result of human creativity and curiosity. When invention is associated with commercialization, it is called innovation. Very often we very loosely use the word innovation for invention, but however, as per definition, invention and commercialization together leads to innovation. It could be a process about bringing invention to the market and users, and it does not happen by chance. You need to plan for it. There needs to be a strategic planning when we are talking of innovation. So when we are talking of innovation, and as I said, there's a commercial aspect to it, invention. What we often look into is how do we gain from such inventions? How do we gain from such inventions that we have created? So then comes the topic of intellectual property rights. And as many of you are already aware, intellectual property rights are legal rights. And here the intellectual property refers to, inventions. It could be patents, it could be copyrights, it could be trademarks, it could be industrial designs, it could be geographical indications and trade secrets. Very often, the major intellectual property right tool are patents. It is the legal right for inventions, and it gives a 20 years protection of any invention that is made. Here, of course, the requirements for the grant of a patent are very robust and intricate, and I'll come to it a little later. When we are talking of literary and artistic works, the intellectual property rights that is often associated with such work is copyrights. And it is, as I mentioned, these are all legal rights. It is for a lifetime of the author plus 60 years. Often we would have also heard of trademarks, and these are legal rights for signs for distinguishing goods and services. And then comes the industrial designs, which are, the legal rights for ornamental or aesthetic aspects of articles, 2-dimensional and 3-dimensional. And it gives a 10-year protection, which can be renewed for an additional time. However, patents cannot be renewed. Geographical indications are the legal rights for the qualities, reputation, and characteristics of goods and products attributed to a particular geographical location. And here, the protection is for 10-year periods and it can be renewed. Trade secrets, I think often we have heard of Coca-Cola. It's a trade secret, and it is the legal rights for the confidential information that may be sold or licensed. So there are other intellectual property right tools also, but these are, some of the major ones that that we often come across. And how are all these intellectual property rights used in the sense of, in the context of the informal sector? And that is what, largely my talk is all about. When we are talking of informal sector, we can talk about agriculture, where we are talking of landless laborers, small farmers, artisans, animal husbandry, and many other things. When we are talking of industry, it could be the workers at the bricklines, construction, beady making, incense stick making, and many more. When we are talking of services, these are all workers in the local transport, shops, domestic servants, and many more. Then you have small workshops where it could be shoemakers, garment makers, embroiders, and even, the blacksmiths and the kinds. Now at home, we have the garment workers, artisans, and craft producers. And of course, when we are talking about the other things other than land, we talk about the fishermen, shippers, and other things. So as one can understand, the informal sector largely belongs to the underprivileged society. And when we are talking of intellectual property rights, it's more like, for an industrialization, for commercial profits. Whereas when you're talking of, intellectual property rights in the context of the informal sector, it is more towards protection of their livelihoods. As such, the means for their livelihoods is very small. And we are talking of the commercial rights, which can be taken away by somebody else. It is about the loss of their livelihoods. So when we are talking of intellectual property rights in the context of the informal sector, we need to appreciate and respect the fact that it is linked to people's livelihoods and it is their right to protect their livelihoods. And why is it important, when we are talking of the informal sector? It is because there are lots of local traditions in India. Okay. And if in case you talk about the tribes, which are largely associated with the traditions, they are almost close to about 705 scheduled tribes, and they constitute close to about 10 to 11% of the total population in the country. And each of their community is associated with one form of traditional cultural expressions or the other. And of course, there are several organizations that have been, systematically looking at these livelihoods of such people, the trade that they are associated, the work that they are associated with, the knowledge that they are associated with, and ensuring that these people's rights are protected. But how is, all this linked to grassroots and innovation? Grassroots and innovations is another form of an innovation, which is kind of, comes under the ambit of perhaps traditional knowledge, but it is more of an improvisation to meet the needs of the time. So when we are talking of grassroots innovation, these are innovations by the common people with no formal education. They could be self-employed or working in the informal sector. And these are all innovations driven by unmet social needs. These are grassroots innovations. Now, innovations for grassroots is another category of innovation, wherein the individuals or organizations create innovations for the benefit of the communities or individuals who are at the grassroots to improve their socioeconomic conditions. Now, while these are two major categories of innovations of the grassroots, there's one another category which is called the innovations and grassroots. So these are, innovations which are jointly done by the NGOs, formal sector of individuals in the informal sector, or unattached professionals or companies, along with the local people. So these grassroots innovations are all important in the context that, when we are talking of India, the informal sector forms the larger part of our society. And here I would like to refer to Professor Anil Gupta's book, Grassroot Innovations. The minds on the margins are not marginal minds. So there is creativity, there is inventive curiosity in these people as well to address their local needs, their unmet needs. And this is typically so even in other deprived countries such as South Africa, where there is a lot of emphasis on grassroots innovation. And here I would like to quote Patrick Krappe, who from South Africa, who says innovation and invention are not the exclusive remit of the haves and the educated. So as I had mentioned, these are all innovations which are from, the bottom of the society, of the economic pyramid. And of course, these innovations cater to a special need of the local region or the society at large. So some of the examples of grassroots innovation are machines for Pochampalli sarees, cotton stripper machine, then you have a herbal formulation from skin disorder. As I had mentioned, some of the grassroots innovation also are based on the traditional knowledge that has been passed on from generations to generations. And some of the examples from other countries that comes under grassroots innovation are a particular community in Kenya. What they had used is that they had used simple bags and grew spinach in them. So this is also a form of innovation that is called the grassroots innovation. Then there is a child who created a pedal for pulling out water, and this is again from Tanzania. The briquette stoves from China also is an example of grassroots innovation. So as I had mentioned, these are all innovations related to addressing a particular need, which is either underprivileged or is not, given enough importance. And these all address a societal need. So here is again one another example wherein this particular person, Raju Mupparapu from Telangana, had created a device wherein he could save the electricity bills of several hundreds, across the Telangana. And this is again a very important example of grassroots innovation. Now coming over to traditional knowledge, what we also see is that very recently in the last few years, there is recognition of, several of these people associated with high impact societal work, and they have all been recognized by the highest civilian awards, the Padma Awards, and have been fortunate, and these have all been associated with traditional knowledge of some kind that would address the societal needs. For example, when we are talking of particular, let me give you an example of this particular bow maker from Sikkim. He's an 83-year-old person who makes bows and arrows in the old-fashioned way. In today's context, perhaps it might not have much commercial benefit, but it is because of his passion, he continues to make that. But now think of it that, you have the younger generation who would like to have a livelihood, means of livelihood. Would they still go about making the straight arrow bow? As per the traditional means? Perhaps not, because eventually every activity that we do must be linked to a means of livelihood creation, employment generation. If you are deprived of that, you tend to lose that. And that is where the importance of documenting and recognizing traditional knowledge becomes important. And I would like to draw to the attention of all joined here an African proverb that says, when an old man dies, a library burns to the ground. And that is the emphasis that I would like to lay here, that, while it is important to recognize that there is traditional knowledge across the country, across several communities, both in the urban and the rural areas, it is also important to document such knowledge, because, the younger generations are now losing interest in their community knowledge, and it is important because this traditional knowledge holds relevance not just today but for our futuristic needs as well. So I now shift gears and then talk about the IPR once again. And here the reason so is that because when we are talking of all these people's rights and people's livelihoods, why is it IPR rights are important? When we are talking of patent, I think all of you are aware that, for every patent application, your invention should meet three important criteria. One is the novelty, the second one is the inventorship, the third one is the applicability or utility in an industrial context, or the use of it. While the Indian Patent Act does specify these are all the things, it also specifies certain of the sections where patents cannot be granted based on the application mentioned, the invention mentioned in the application. So I'll just refer to two of the important criteria when we are talking of patents. We are talking of invention. So as per definition, what is invention? It means a new product or a process involving an inventorship and capable of industrial application. So anything novel that we create falls under invention. Is that so? From a patent point of view, no, because it also needs to meet the criteria of inventorship. So what is inventorship? As per definition, inventorship means a feature of the invention that involves technical advance as compared to the existing knowledge. And I would like to draw your attention to the fact that, the phrase here, the invention should not be obvious to a person skilled in the art. So here I would like to lay emphasis again that when you're talking of inventorship, to meet the criteria of patentability, the invention that is mentioned in the application should not be obvious to a person skilled in the art. I'll explain this particular part a little further. when we are talking of inventions not patentable. As I had mentioned, Section 3 of the Indian Patents Act does refer to inventions that cannot be patented. So here I would like to draw your attention to the fact that when you are talking of traditional knowledge under Section 3P, an invention which in effect is traditional knowledge or which is an aggregation or duplication of known properties of traditionally known component or components cannot be patented. So I'd like to elaborate this a little further. Say, for example, when we are talking of amla or ashwagandha or maybe any another herb, maybe turmeric, let's take turmeric, and which are all known to have, say, amla, we talked ashwagandha, and yeah, so hepatoprotective effect. So in this context, what is important is that, say, if all the three herbs individually are known to have known properties for hepatoprotectivity, and you combine all the three and then make a new formulation, the question is that, is this patentable? In essence, because it is an aggregation or duplication of known properties, as per Section 3P, it is not patentable. And why so? I did mention previously that it needs to meet the criteria of inventorship. And here I had laid emphasis that the invention should not be obvious to a person skilled in the art. So when we are talking of amla, turmeric and ashwagandha, so you know that individually all three have this property, and by combining this, say you are expecting a 5-fold or a 10-fold increase in activity, it is supposedly or perceived to be obvious to a person skilled in the art. But your particular combination, formulation has created something, say, of 50-fold enhancement in activity. That is something which is not obvious to the person. So you meet the criteria of inventorship. But here in this context, I would also like to draw your attention to the fact that under Section 3D, an invention that is a mere discovery of a new form of a substance or a new use of a substance cannot also be patented. So in this context, we need to be extremely careful about what can be patented and what cannot be patented in the context of traditional knowledge and as well as grassroots innovation. Prior art, that is literature already available, needs to be considered when patents are being granted. So these are this is, in one way, is both the protection and as well as, and here you call it as a defensive protection of traditional knowledge, because it defends others from claiming ownership, claiming monopoly on that particular knowledge. Yeah, now one another tool of protecting traditional knowledge-based goods is geographical indications. As I had mentioned, these are all goods associated with a particular geographical location in the country. It is not limited to only bioresources. It could be anything. It could be the textile, that is the Asomia, Japi, Gamocha, Japi, Nagpur orange. It could be the Tanjavur painting. This is all, as you see from the names, they are all associated with a particular geographical indication, so geographical location in the country. So typically the geographical indications are associated with agricultural products, foodstuffs, wine and spirit drinks, handicrafts, and industrial products across all domains. They are registered as collective and certification marks. Unfortunately, the products are all associated with protection through the legal rights. The underlying traditional knowledge is not protected under the geographical indications. And here one can, it cannot be assigned or licensed to someone else because that particular geographical location of that particular good is important for branding perspective. So whereas patents can be licensed out. Another form of protection of the traditional knowledge, or as well as the grassroots innovation, is the industrial designs. Here the design means the features of shape, configuration, pattern, ornament, or composition of lines or colors. It could be two-dimensional or three-dimensional, and in both forms, and by any industrial process or means, whether manual, mechanical, or chemical, separate or combined. The protection rights are for a period of 10 years and can be renewed once for an additional 5 years period. And it provides rights that may be sold or licensed, unlike the geographical indications. Some of the designs that the National Innovation Foundation has applied includes self-balancing attachment for plate to hold containers, cooker, refrigerator, tawa with handle. These are all, as I had mentioned, two-dimensional or three-dimensional aspects of a particular product. So it also provides legal rights to the inventors. When we are talking of bioresources, especially those associated with traditional knowledge and grassroots innovation, another tool for protection, especially of plants, is the protection of new varieties of plants, and it is under the Plant Varieties and Farmers' Rights Act of 2001. Here it is an effective system for the protection of the plant varieties, and it can range anywhere between 15 to 18 years, depending on the type of the crop. It provides the rights for the farmers and the plant breeders. It is also important from a research and development perspective, and as well as the growth of the seed industry. It ensures by this particular plant varieties protection tool, it ensures that there are high quality seeds available and the planting materials of improved varieties are provided to the farmers. So these are largely the legal tools that I had mentioned so far. We will move a little forward, in terms of, the other forms of protection of, such innovations. And one very important aspect is the Biological Diversity Act 2002, under which the regulation to the access of biological resources and its associated knowledge is controlled. Under the Biological Diversity Act, which is enabled by the National Biodiversity Authority, the norms are stipulated for access to the biological resources. So it could be to the foreign citizens, companies, or non-resident Indians, where prior approval of the National Biodiversity Authority is required. And similarly, for Indian citizens and companies and associations, prior intimation to the State Biodiversity Board is important. Here, under this Biodiversity Act, results of research are not to be transferred to certain persons without approval of the NBA. Similarly, when you are applying for intellectual property rights, such as patents, it is not to be made without the approval of the NBA. So forms are specified. And for example, for Form 3, when you are applying for the intellectual property rights, inventions based on any research or information on a biological resource obtained from India, it needs to be informed to the NBA, and their approval is required before the grant of the patent. The National Biodiversity Authority is also associated with protection of traditional knowledge associated with bioresources. And how is it so? It is under the tool of the People's Biodiversity Register. And here this People's Biodiversity Register is enacted or implemented by the Biodiversity Management Councils, which work at the village or the panchayat levels. What they do is that they go about the villages, talk to the knowledge holders, inform them. There's a free and prior informed consent taken before gathering information on the bioresources and their associated use. And that knowledge is collected in the form of a register with a very specified format. This is called the People's Biodiversity Register. And this ensures that this knowledge is gathered. The community associated with it is also mentioned in the People's Biodiversity Register. So when one accesses such information and as well as bioresources, you need to ensure that by accessing the knowledge, benefits that you accrue is also shared with them. So that is what it means by equitable sharing of the benefits arising from the use of such bioresources and knowledge. This addresses the issue of biopiracy as well as it conserves and sustains bioresources. And as I had mentioned, the emphasis is on prior informed consent and access benefit sharing. So these are largely the tools available when you are talking of innovations associated with traditional knowledge or grassroots. And here, I had mentioned under the patents where, patents cannot be filed on certain of the inventions, that it is a defensive protection. So what is defensive protection of traditional knowledge? It is the strategy to ensure that third parties do not gain illegitimate or unfounded IP rights, because every IP right is a legal right which provides the assignee the commercial rights, the ownership rights of that particular knowledge that they can monopolize, and that way they actually eliminate livelihoods of people associated with such knowledge. So in order to provide misappropriation of such knowledge, we have this defensive protection tools. But when we are talking of traditional knowledge, including grassroots, what is also important is the positive protection. Herein, positive protection refers to creation of legal rights to those traditional knowledge holders to protect and promote the traditional knowledge without the fear of it being misappropriated by other people. Internationally, countries such as Ghana, Peru, and all have national laws that provides the indigenous knowledge holders a path for legal recourse. However, in our country and many other countries as well as, we do not have any legal systems to protect such knowledge. Unfortunately, if you look at the bottom part of the slide, this knowledge is all associated with people with very poor means of their livelihoods. And there are lots of issues associated with such protection. And the concerns, some of them I have listed on this particular slide is, what do you define how do you define traditional knowledge, cultural expressions, and what needs to be protected? Who should benefit from such protection? Because especially in our country, despite the diversity, we have such pools of knowledge associated with several communities, and the knowledge might be very similar. So the systematic efforts need to be brought in to, kind of bring all this knowledge on one platform to see how many of these communities are associated with such knowledge. Because if one makes a commercial benefit of such knowledge, all the people associated need to be given the benefits of such commercialization. The next, what is very important is that while we are talking of preventing others from taking intellectual property rights, it is also important to see what is traditional knowledge and what is improvisation of such knowledge. Say, for example, the grassroots innovation, and how do we accord intellectual property rights to such improvised knowledge? What forms the basis of inventorship and the novelty associated with that? And then what is also important is that, what forms of behavior is required and should be considered unacceptable and illegal when we are protecting such knowledge. Should there be any exceptions or limitations when we are associating such rights? How long should the protection be? To what extent do existing IPRs already afford protection? What are the gaps need to be filled? What should be the penalties that should be applied when illegal activities undertaken? What issues need to be dealt internationally and which has to be addressed nationally? There are many complicated and complex problems associated with such protection, because such knowledge, because it is not largely documented, it creates a lot of issues, because it could be, the knowledge of one particular individual, or it could be part of one community, or could be part of many communities. So these are all to be taken care of when we are talking of protection of, the rights of the people associated with such knowledge. But what whatever we say, when we are talking of intellectual property rights, when we are talking of modern science and technology, it's rather easy, because when we are talking of a particular invention, it is associated with a particular person, because you have your lab notebooks to, kind of mention that this is, experiments done in your laboratory, and you can go and prove that, these are all work done by you and your group of people. But when you're talking of traditional knowledge, that is not the case. There are a lot of gaps, and there are a lot of gray areas associated with it. So and what is more important is what I had mentioned previously, that such knowledge is associated with the rights of the people associated with it. It is their means of livelihood. So in this context, what is most important is an ethical framework. So what constitutes the ethical framework? One is a free prior informed consent. What is free and prior informed consent? It is not a mere, discussion with the particular knowledge holder or the community, saying that, हाँ आपके पास ये knowledge है, आप हमारे साथ share कर दीजिए. That is not the, prior informed consent. You need to talk to the, knowledge holder or the communities associated in depth to indicate what are the pros and cons of sharing that knowledge with us. How are we going to use that particular knowledge after documenting that knowledge? Should we derive commercial benefits out of such knowledge? What is the action plan that we have in terms of sharing the benefits with them? All that needs to be explained to them in advance, and only after they have understood it very well, you take their consent and document such knowledge. Very often as researchers, we also forget that, once we have gathered this information, we go about doing our R&D and then go about publishing the research articles at all, often forgetting that it is the knowledge holders who have provided the base for such R&D. So acknowledging the contributions of the knowledge holders becomes extremely important. It could be in the form of authorship, it could be in the form of inventorship, it could be in the form of partnership when we are talking of commercial benefits. So after the prior informed consent, it is also extremely important to acknowledge the contributions of the knowledge holders. The last but not the least is the benefit sharing. I think, I have laid enough emphasis in my earlier slide, but when we access their traditional knowledge and we make, a value added product out of such knowledge, it could be an improvisation of such knowledge, or it could be the knowledge answers. And when we derive benefits out of such R&D, the benefits need to also be shared with the community associated, with the knowledge holder associated. So these are, the critical aspects of an ethical framework when we are talking about traditional knowledge, especially oral traditional knowledge that has not been documented so far. So I did mention about the free and prior informed consent. In fact, WIPO has brought about a toolkit that says, we need to, when we are talking about, oral traditional knowledge that has not been documented, we need to make sure that the interests and concerns of the indigenous people or local communities is understood. We define the objectives of the documentation project, who leads the documentation, how should it be done, what should be the role of the different actors who are involved in that documentation. And one of the examples that they have given is the effort that I am leading from CSIR, the Traditional Knowledge Digital Library. I will talk about it in a couple of slides a little later. And when we are gathering such information, if possible, we also need to make an assessment of the intellectual property aspects, if in case that particular knowledge is, unique. And also we need to have, they have also given an annexure which talks about a documentation project. Before documentation, what needs to be done, during documentation, what needs to be done, and after documentation, what needs to be done. This particular framework is also important when we are documenting traditional cultural expressions such as literary works and local traditions. I did mention about acknowledging the knowledge holders. I give you examples of two papers that I have pulled out from India. On the left side, you see methods, field survey, and data collection. And this is, if you look at the this one, the sixth line, it clearly says prior informed consent was obtained from the respondents before interviewing them. So this is a good way of acknowledging and also mentioning that, you have taken consent of the knowledge holders before embarking on your either your survey or your R&D. But if you look at the other side of this slide, the right side of the slide, you see there is a large, materials and methods paragraph. However, across this large paragraph, nowhere is it mentioned that the prior informed consent of the knowledge holders was taken. So I emphasize that when you are documenting such knowledge, make sure that you follow good documentation practices, and also please provide acknowledgement to the knowledge holders whenever you gather such information from them. The third aspect is the access benefit sharing mechanism. So way back, even before the National Biodiversity Authority took its birth, the the Biological Diversity Act came into place. We have an access benefit sharing framework that was created for the Kani tribes by Dr. Pushpangadan way back in 1994. And here, this is based on a herbal drug Jeevani from the knowledge of the tribes, the Kani tribes of Kerala. And based on that biological lead, there was a product that was developed by the Jawaharlal Nehru Tropical Botanic and Botanic Garden and Research Institute, that is the JNTBGRI. And this particular knowledge was transferred to the Aryavaidya pharmacy. The production technology was transferred. So as part of the agreement, there was, JNTBGRI included the Kani tribes. So 50% of the royalty and license fee was transferred to the Kani tribe, and the Kanis formed a trust that implemented community welfare programs arising out of such benefits. So this is an example of the access benefit sharing mechanism. So following that, the National Biodiversity Authority also, as I had mentioned, whenever you use bioresources, you need to follow the regulations stipulated under the Biological Diversity Act. So the access benefit sharing mechanism is also enacted and implemented by the National Biodiversity Authority. And this particular slide talks about certain of the cases wherein the benefits have been shared with the communities. One is the seaweed that is, that is exported by PepsiCo. The neem lines by the Biological India, Bio India Biologicals, the Falmake by the Natural Remedies Private Limited, and the anti-snake venom Ayurvedic product by a particular individual, a doctor, an Ayurveda doctor. So in all the cases, certain portion of the benefits that has been accrued by the NBA has been shared with the communities for their own welfare. So as I had mentioned, access benefit sharing, there is a framework under the National Biodiversity Authority, Srishti, that is the program that we are attending, from Srishti, also has a mechanism put in place, and they also have a formula. So here I'd like to emphasize, the various categories under which the benefits are shared. The innovator gets 30%. For nature, you have a delineated 5%, for the community 5%, innovation fund 20%. This is to help the healers, herbalists, and innovators. Then for research and field trials, you have demarcated 15%, overhead expenses fee 15%, contingency 5%, and what is also important is women knowledge promotion fund. 5% of it is attributed to that. So this is, these are all certain of the examples that one can emulate to ensure that when we are accessing such knowledge of the people, we also share benefits with them. I did mention about the word misappropriation. Not sure if many of you had understood what it is. So here, when we are talking of misappropriation, as I had mentioned, when you are talking of patents, patents are what legal rights, and these are legal rights that would allow monopoly of the patent holders to exercise their rights. And by this, you are giving an exclusive IP ownership for profit. But however, when this knowledge is part of somebody's knowledge and you are gaining commercial rights, what is it called? It's called misappropriation. You are appropriating somebody's knowledge for your own, selfish needs, and this is something that needs to be tackled extremely carefully where we are talking of traditional knowledge, because this is all linked to people's livelihoods. And when bioresources are used without following the regulations of the country, it is also called biopiracy. And this has been the case when we are talking of turmeric, basmati, and fungicidal. Way back in 1993, patents were filed on turmeric for wound healing. The patent was also granted in 1995 by the USPTO. Basmati rice lines were also was also patented way back in 1994, and it was granted in 97. The fungicidal formulation of neem was filed in 91. It was granted in 1994. So what did it all relate to? So when a patent is granted, legal rights are granted. That means we have lost ownership of such knowledge, which we have been practicing as traditional knowledge, sometimes in our everyday life. So here the government of India took a very strong move to ensure that these patents are either revoked or amended. But it took a lot of efforts and a lot of time, a lot of money to ensure that such patents are not granted. It took anyway between 3 to 11 years to ensure such patents are revoked and the rights of India are retained. So in this context, what I would like to draw your attention, especially from an IPR perspective, is when we are talking of traditional knowledge, it is that knowledge, which, especially from a patent perspective, we need to ensure that such knowledge is, known to the patent examiners as prior art. What is prior art? Prior art is any evidence that the invention is already known. Unfortunately, for us, where Indian traditional knowledge is concerned, and similar is the case with other countries with rich traditions, this particular knowledge is not a part of the PCT minimum documentation. PCT minimum documentation is the documentation that patent examiners refer to. It could be patent literature as well as non-patent literature. It is, the collection of journals and articles that are referred by the patent examiners when they are looking at patent applications from the perspective of novelty and inventorship. Unfortunately, none of our traditional knowledge books are part of the PCT minimum documentation. And one of the obvious reasons is if you are looking at our traditional knowledge, it can come in any form, it could be in any language, and it is not easily understandable by patent examiners from a modern language or science and technology perspective. So understanding the gap, the government of India then thought about creating a traditional knowledge library, and thus the TKDL, that is the Traditional Knowledge Digital Library, took its birth. Based on the commercial interest of the time, we embarked upon documenting information related to Indian systems of medicine that includes Ayurveda, Siddha, Unani, Yoga, Sovarika. And so far, we have transcribed close to about 4 lakh such formulations. We also have included yoga techniques into it. And this is all based on, because it's all from an IPR perspective, this particular database is based on what is called the TKRCs, that is Traditional Knowledge Resource Classification Codes. It is a structured content, and this particular knowledge is available in English, French, German, Japanese, and Spanish. It is a value-added information that is there in TKDL. I would request each of you after this program, you can go refer to the TKDL website to see what is the information that is available in the TKDL. However, the full access of TKDL is provided only to patent offices, whereas only close to about 1,250 such formulations are accessible by everyone. And in addition to providing this particular knowledge as a prior art database to patent offices, the TKDL, we also file pre-grant oppositions and third-party observations. And these are tools available with major patent offices across the world, wherein based on whatever evidences that we have, documentary evidences that we have, we can file an opposition on any patent application wherein we feel that the particular application does not meet the criteria of novelty or inventorship. And based on the strength of the evidence that we provide, the examiners take a call whether to share that information as an observation with the patent applicants, so that appropriate action is taken and responses are received. And this particular activity of pre-grant oppositions and third-party observations often lead to patent amendments, revokement, withdrawal, or abandonment. So this is largely about the work that we do. So this is, TKDL is a defensive protection of traditional knowledge. With this, I would like to close my talk. Thank you so much for the opportunity.
Thank you so much, Doctor, for an excellent talk. Students, if you have any doubts or clarifications needs to be asked, you can ask Dr. Viswajanani. Any questions? Is there, everyone is there?
Yes, sir.
Yeah. Yeah. So, you have any doubts regarding IPR, patenting, or traditional knowledge, you can ask her. She has a vast experienced person.
I hope I was clear.
Yeah.
Hello, ma'am.
Yeah, yes, please.
This one yesterday when I was interacting with one of the farmers, so they shared me some of the traditional methods of farming like that. So while implementing, should we have to get a consent form from them?
Yes, please, you should, because you do not know whether this particular knowledge is already known elsewhere or not. So as mark of respect to the knowledge holders, you please take a prior informed consent. In fact, Srishti, that is under the Honeybee Network, as well as the National Innovation Foundation, has a very wonderful prior informed consent form, okay, with explanatory notes. I would urge Dr. Murugan to share that with all the participants, so that they understand the importance of talking to the knowledge holders on the pros and cons of they sharing that knowledge and what do we intend to do with that knowledge. You'll have to explain to them, Amulya, that if you are intending to do R&D on that particular knowledge, you have to inform them that this is the activity that you plan to undertake. And once you get the results, once again inform them what are the results be and what is it that you intend to do further on.
Sure, Doctor, we'll do that.
Yes, ma'am. Thank you.
Hello, good morning, ma'am.
Yes, sir.
Ma'am, I had a doubt that I will share an example that we know that neem leaves are good for air purifying and trapping pollutants. So if a company or an individual uses these unique properties and in a device, like for example, an air purifier, and that will be the novelty of that device. So can it be patented? Can that device be patented? Because we have used the traditional knowledge as the novelty.
Yeah, so here, Saurabh, the thing is that as a device, you would be able to go about, filing a patent on that, but you need to be, what is important in any patent application is what is it that you are claiming, Okay, the claims are very important, and that defines the legal rights for you. Okay, so here, as long as you do not claim that it is the name lease that is, important for the particular activity, okay, and you're not claiming the property of the name lease to reduce the pollution, you are okay. Otherwise, you would be actually infringing upon the traditional knowledge rights, and on that particular claim, you will not be granted the patent application. The device as is, you will be able to file a patent on. Am I clear?
Yes, ma'am. Thank you, ma'am.
Yeah.
Any other questions? So every one of you is going to work on grassroots practice, right?
So, are we having R&D session for all? Are they going to do R&D at their own colleges, or how is it planned this time?
Depends upon the situation, Doctor.
I know.
Yeah, because of the COVID situation, we are encouraging students to do in their host institute.
Okay.
If many of them are not, some facilities are not there, then they can come here and do work.
Okay. Okay.
Currently, we have 3-4 students are working here. From the past BIIS, they are doing the research here.
Okay. Okay.
And some we are doing the home experiment. Also, professor has ignited them to do home experiments. What are the resources available with them within their surrounding, within their home? They can do small projects on them. Professor is also emphasizing on that.
That is good. That is good. Actually, it helps, coming up with new solutions. The creativity is
Every day in life, we are using so many things, but we little bit of improvements or innovations will be good for them to take the product, to develop into a product prototype, bring it to the market. I think no more questions is there. Yeah, then thank you so much for your time today.
Thank you so much. I would urge all the participants to remember 3 things: informed consent, acknowledgement, and access benefit sharing. I think that lays the foundation for grassroots innovation. Thank you so much. Thank you so much, Dr. Murugan, for the opportunity.
You can share your slides to me, ma'am. I will pass to the students.
Sure.
Yeah. Thank you.
Thank you so much. Thank you.
So the next session will be around starts by 11:30. We have a 1 hour break now, half an hour. Okay. So we'll resume back at 11:30. Okay. Thank you.